Welcome to the 2020 RMIT Higinbotham Lecture. I'm Professor Kathy Douglas, Dean of the Graduate School of Business and Law. Shortly, my colleague, Deputy Vice-Chancellor, Professor Julie Cogan, will introduce our guest speaker, the Honourable Jill Hennessy, Attorney General of Victoria. Firstly, though, I would like to do the Acknowledgement of Country. RMIT University acknowledges the people of the Wurrung and Boorong language groups of the Eastern Kulin Nations, on whose unceded lands we conduct the business of the university. RMIT respectfully acknowledges their ancestors and elders, past, present and emerging. RMIT also acknowledges the traditional custodians and their ancestors of the lands and waters across Australia where we conduct our business. This annual lecture celebrates the legacy of George Higinbotham, an important figure in the history of RMIT and Victoria. This is an important event to us at RMIT Law, and I especially welcome our students and future students tonight. This lecture highlights our connections with the legal and human rights communities in Victoria and nationally. The timing of this year's lecture is, of course, of particular importance, as we are currently launching our Bachelor of Laws and combined degrees with their first intake in 2021. These new additions to our industry-connected Juris Doctor program will offer students a pathway to legal practice with a strong focus on law and technology, along with business and human rights. I'm sure you will enjoy tonight's lecture by the Attorney General, followed by a Q&A panel with our own legal experts. I'll now hand over to Professor Julie Cogan, who will introduce our guest speaker and panel.
Thanks so much, Kathy, and good evening, everyone. I'm very pleased to be here today introducing our guest speaker, the Honourable Jill Hennessy MP, Attorney General and Minister for Workplace Safety and Minister for the Coordination of Justice and Community Safety in the Victorian Government. The Attorney General entered the Victorian Parliament as a member for Altona District in 2010 and held a number of shadow ministerial roles before she was elected to government in 2014, including public transport, anti-corruption, corrections, crime prevention and women. Her commitment to modernising the Victorian legal system has delivered smart, fair and transparent justice, which has been the driving force behind a number of landmark reforms, changing the lives of many Victorians. And just like the Attorney General has a compelling vision for Victoria, we also have an exciting vision for our students in the College of Business and Law. We're delivering world-class education with a distinct focus on emerging technologies in law, human rights and innovative justice, all informed by the amazing high-quality research conducted by our academic staff. Currently, the Attorney General is at the helm of various changes to the law implemented in response to the major health and economic challenges of COVID-19, and we're thrilled to have her speak on this topic today. So let me tell you how we're going to structure the evening. The Attorney General will deliver her lecture for around 30 minutes, and even though I'm told she'd like to stay for the whole event, she does have to depart for another commitment, and I'm sure everyone can appreciate there is a lot going on for her at the moment. So the lecture will be followed by the panel discussion, and panellists will give a brief response to the lecture and then take questions from the audience. And throughout the event, questions, comments and responses can be posted in the chat function of Teams, and our moderator is going to give preference to the most popular questions. So be sure to like your favourite ones. So it gives me great pleasure to introduce the Honourable Jill Hennessy, Attorney General, MP.
Well, thank you very, very much, Julian. I'd like to begin my lecture, obviously, by acknowledging the traditional owners of the land from wherever we are tonight, and I want to pay my respects to elders past and present. I want to acknowledge the many members of the judiciary that are here tonight, including Chief Magistrate Hannon, as well as the President of the Children's Court, Judge Chambers. I also understand a very dear friend and colleague of mine, former Attorney General Rob Hulls, now Director of RMIT's Centre for Innovative Justice, is with us, and I'd really like to acknowledge him. And I also want to acknowledge all of the wonderful RMIT staff, including Professor Anthony Forsyth, who've organised this event along with his colleagues, and to thank Julie for her terrific welcome. And I'm very, very honoured to have been invited to deliver RMIT's lecture this year, and the calibre of past Higginbotham orators is a testament to how highly regarded this event is. And before I begin tonight, I want to just recognise the very extraordinary circumstances that we find ourselves in. We aren't converging on a lecture hall on a mild Melbourne spring night tonight, complaining about the public transport or the parking or how long it took us to get a pre-lecture drink. Victoria, unfortunately, is in a state of disaster, and we're facing a global health crisis, the likes of which no community has ever had to confront in the past 100 years. And as of the 8th of September, the Johns Hopkins University COVID-19 dashboard tells us that there's been over 27 million coronavirus infections in 188 countries, and that globally there's been over 890,000 deaths. 189,000 of those deaths has been in the United States alone. And the title of my address tonight is The Victorian Legal System in a Global Pandemic. But the title might be a little bit deceptive, because I'm going to talk about the legal system, but I also want to talk about the very extraordinary challenges that Victoria and the world is facing. And I want to really highlight how COVID-19 has forced us to confront and to try and really focus on committing to new ways of understanding the role of the state and what the role of the state means for the rule of the law. So there's been many, many, many days full of great trials and tribulations, and I really want to try and challenge you to try and think about how all of these challenges and circumstances might think you to think about what the rule of law, what law reform, what the role of the state, and what your personal kind of views might be in the future. Before I do that, I just want to briefly acknowledge and touch on the story of George Higinbotham. And I must say that before being invited to address tonight's lecture, I didn't know a great deal. But after reading a little bit about George Higinbotham, I've got to say that he sounds like a man after my own heart. He was an Irish reformer, and as a Hennessy, that's not a matter that is lost on me. He was a supporter of women's suffrage. Again, another point that is very, very dear to my heart. He was an immigrant that held the esteemed offices of the editor of the Melbourne Argus, a member of Parliament, the Attorney General, and the Chief Justice of Victoria. And I'm pleased to say that he didn't hold all of those offices at the one point in time. And I imagine if George had have been around today, and I'm sure he was a person that would not mind me referring to him as George, that he would be very acutely interested in the impact of COVID-19, particularly on those least able to combat it and the role of the law in responding. And I'm informed by Professor Forsyth that it is Higinbotham's connection to RMIT that inspired this lecture series in his name. Higinbotham was the first speaker at the town hall meeting that established the Working Man's College, later RMIT, which sprang out of the 8-hour day movement, and that he felt very strongly that this new institution should have a liberal curriculum, and most importantly, that it should be run by the working people of Victoria through their trade association and through their unions. Higginbotham's views have been described as radical, and that might be certainly true for the time. Some of his views might even be seen as radical today. And in an article called "The Irish and the Law of Australia," former Chief Justice Gerard Brennan wrote that as Chief Justice in 1887, he made it clear that if he was appointed acting governor, the Lieutenant General while the governor was on leave, he would refuse to communicate with the Colonial Office. He refused the customary knighthood. And during the maritime strike of 1891, he publicly sent £50 and a further £10 per week towards the relief of the strikers' families. Well, if that's radical, I welcome that kind of radicalism. I want to now talk about the novel coronavirus. And whilst Victoria recorded its first COVID-19 case on the 25th of January, even at that time, I think that most of us felt that whatever the nature of this very, very mysterious virus, we thought that it was unlikely to disrupt our daily lives in Melbourne very much. But by on 16th of March, the Premier announced a state of emergency to give our Chief Health Officer the powers to enforce isolation requirements and to cancel mass gatherings as agreed to by the National Cabinet. And by that time, COVID-19 was wreaking havoc throughout Europe and the United States. The world was thrown into a level of alarm that only the smallest handful of people alive today had ever known before. We knew then that the government's singular focus was incredibly important to protect our community and our health system from being overwhelmed. Whilst we always seem to watch other jurisdictions with alarm, we sometimes underestimate the impact that it will have on our own. But we also knew that the focus would be both on the implications of the enforced isolation, that there would inevitably be a debate and a controversy known to many people in the legal profession, but also amidst the wider community, especially those that are very, very engaged in human rights debates about how these sorts of issues that government have to decide about the debate between protecting the individual versus the collective rights, and what are the legal implications and options around restraining the power of the state. But also I think that the Corona-19 crisis has really exposed and focused a range of important issues for us. We all desperately want our lives to go back to normal, but COVID-19 has shown us that we shouldn't necessarily be advocating to a standard normal way of working. What it has done is it has inherently exposed the fault lines that exist in our community. It has exposed and exacerbated things that we knew existed before, but we perhaps underestimated the implications, and their significance was perhaps underappreciated. And it is essentially my argument that we should use this crisis to ask, how can we better channel our efforts to reduce inequality? How can we turn our mind's eye to those in the community who are struggling to keep their head above water in the toughest of circumstances? Corona has placed a microscope on inequality in our community, and the burdens are absolutely being demonstrated to be shown to be falling on those in insecure work and on frontline workers who can't sustain their livelihoods from home. I am a big fan of the writer James Baldwin, and he once said that anyone who has ever struggled with poverty knows how extremely expensive it is to be poor. And COVID-19 has exposed this fact in the starkest of terms. The burdens of COVID have fallen on those that are in precarious work, those that live in our outer suburbs, on our elderly relatives who have given so much and are in an aged care system that in many cases have been demonstrated to fail them. The burdens are falling on international students, an economy upon which we so deeply rely here in Victoria, on those that are socially isolated. The burdens have fallen on women and children that are facing family violence. The burdens have fallen on those that have spent their life building businesses. These are urgent problems, and they go to how we organise ourselves as a society. The cracks in social organisation are always opened wide by catastrophic events, such as the ones that we are facing now. And it is understandable that we can feel very impotent in the face of those. You may have noticed that those that have been demonstrating or arguing against some of the interventions to try and protect our community have often relied upon the argument of human rights, whether that be the Universal Declaration of Human Rights to make their case, or our own wonderful Victorian Charter of Human Rights. The wheels of the human rights movement bandwagon, we've got many new friends. They squeak as those jump on, and I want to say that all are welcome. Don't get me wrong, I vehemently believe that it's critical that people have the power and the ability to debate the limits of government authority and law now more than ever. We are living that debate in real time. But it is often, though not always, that those who sit comfortably behind a computer screen, like many of us tonight, working remotely, but many of those who enjoy that slight discomfort compared to the discomfort of many that have complained the loudest about the encroachment on their freedoms. Those who have relentlessly criticised the COVID-19 restrictions as either too harsh or not harsh enough are often people who debate human rights in the abstract, and their social and economic advantage means that they are often not in harm's way. Their greatest sacrifice is often the round of golf. They aren't nursing patients in intensive care units. They aren't working in an abattoir. They're not juggling multiple jobs to feed a family, and often they are working and they can afford to work in the abstract. But I and many of those I know that have worked hard for the practical application of human rights, both as a legal form and their practical expression, that have joined with us tonight. We know that we can't afford to ever consider human rights as an abstract concept, because rights can never be realised unless people have decent living conditions, including the right to access high quality healthcare, including the right to life, including so many of the very important economic and social rights. Rights are not meaningful when only some get to enjoy that most fundamental of rights, the right to life. Eleanor Roosevelt, a wonderful woman, gave voice to this, I think, in her famous speech on the Universal Declaration of Human Rights, when she asked, where, after all, do human rights begin? In small places, close to home, so close and so small that they cannot be seen on any maps of the world. Yet they are the world of the individual person, the neighbourhood he lives in, the school or college he attends, the factory, the farm or the office where he works. Such are the places where every man, woman and child seeks equal justice, equal opportunity, equal dignity without discrimination. This pandemic has had immense impacts on all sectors of society, and the legal system is no exception. The work done over decades, however, including, I think, the very important development of the Victorian Charter of Human Rights, and I can assure you has been very, very important in impacting upon the decisions that are made. On the 26th of April this year, Parliament passed the COVID-19 Emergency Measures Act 2020, and that introduced a host of very significant measures to mitigate the effects of COVID-19, including important things that realised in other human rights, things like a moratorium on evicting people from their homes, important responses to the challenges that our legal system faced, including introducing, and some quite controversially, judge-alone trials for Victorian indictable offences with certain conditions. The Charter, and I'm very pleased to say this, has not been suspended despite the fact that we are currently living in a state of disaster and have been living in a state of emergency for many points in time. Nor has the right to judicial review, and the fact that many have relied upon the Charter and their rights of judicial review, I think, speaks to the great power and possibility of this importance as a legal instrument, despite the fact that we're in incredibly challenging times. It has meant that as the government has had to make incredibly challenging and difficult decisions, that we have had to consider the Charter, that we've had to debate and consider all of the obligations and ensure that the use of powers is proportionate, despite the fact that we have a very, very wicked and infectious enemy. COVID-19 has meant that courts have had to immediately adjourn all but the most urgent of matters, except for family violence matters and bail and remand hearings. As I said, jury trials have been suspended since March to keep jurors and court users safe, a decision that was taken across Australia and in other common law countries as well. And these changes has meant that significant numbers of matters are now on hold, a fact that will take all of our ingenuity to tackle over the coming year. We know that justice delayed is justice denied, and that we will need to find ways and continue to find ways over the coming years to think very radically about how to organise our legal system so that matters can be heard as quickly and as fairly as possible. A decade of technological advances has occurred across the courts in just 6 months. We have seen that a significant part of the court's work can be done virtually. It hasn't been easy, and it will continue to be incredibly challenging. And I want to acknowledge the tireless dedication of so many of our judges and magistrates and those who glue the system together, our lawyers, those that work in administration, the specialist service providers, all of those that provide the important services around. We had to just make it work, and people are working tirelessly to ensure that that is the case. And it does demonstrate that we can be creative and ingenious when there is no other choice. Whatever our position, whether we are the Attorney General or a judge, we are just another Zoom participant, and we've had to put people at the centre of our needs. We are all occasionally that person who can't find the mute button. Since COVID-19 emerged, the government has also had to take extraordinary measures to combat the pandemic, placing restrictions on everyday life and putting restrictions and interventions to preserve community health of the likes that we've never seen in my lifetime. It's often said that these measures have involved a very complex balancing of health and social considerations. And I want to assure you all that the Premier and members of the government, and indeed all members of the Parliament, are very singularly focused on reducing the risks of COVID-19. We're very acutely aware that you can't just close large swaths of the economy and social life without it having perhaps irreversible impacts on people's lives, their families, the businesses they've spent decades building, and mental health and well-being. We're very acutely aware of those issues. And all of this occurred at a time when trust in institutions globally was waning. In very confronting debates about liberty versus social responsibility, freedoms versus people's health and well-being, people were feeling less inclined to trust the very institutions that had been established to guide them. This was our time, and we need people to trust us. And just as people are losing trust in institutions when it is the most needed, so too are people feeling despondent at a time when we most need them to feel optimistic and energised, or to find some rungs in the ladder to genuinely feel that. We want people to feel positive about the roles that they play in their community, and therefore to help making society well again in all of the senses of that term. This is the balance and the connection that I would argue the law is always working with. But understanding how these two concepts need each other rather than conflict with each other is something that we need to promote more widely. That's why, and we need to make people feel less constrained by the limits to their freedom and more enabled by them. We need to make sure that we're making the argument that it's counterintuitive to argue for a binary thinking that sometimes characterises the COVID debate. There is a view, and I know it was very fashionable when I first became politically active, that it's best not to rely on the state or community, but to rely on ourselves. No one, much less than government, will have our back, was the argument. Even while responding to this crisis, which calls for a huge collective effort to manage our very human impatience, because we all so desperately want a normal life to return. Some ministers have channeled very, very, very anti-community views as a way and a form of inspiration, and it's something that I deeply disagree with. I've never believed in this, and I would argue that COVID-19 has shown us how mistaken an anti-state, anti-government view is. We all desperately, however, need high levels of trust in government and institutions, but we need those institutions to be strong and effective. I want to argue that the anti-state view is empirically wrong. We desperately need the role of the state to stamp out this disease. We literally must turn our mind to modifying our behaviour to protect family, community, neighbours and people that we will never meet. It is essentially a collective task. But most fundamentally, this isn't just about small versus big government. It raises issues about what the community expects of government during a crisis like the one that we are currently in. On the one hand, government is expected to respond to a health crisis with all of the necessary tools and interventions to combat it. And that has required using very intensive, interventionist, controversial, unprecedented legislative powers, with decision-making concentrated in a small number of people. The stakes are very high and the tolerance for mistakes is very low. And in a pandemic such as this one, the legal tools are very, very blunt. This is not a time of nuance and argument. The Chief Health Officer's directions lay down significant restrictions on almost every aspect of our life, on movement, on work, contact with loved ones, and a range of very ordinary activities which give our lives meaning. And does putting so much hands in the powers of a person undermine the role of other forms of the executive and the parliament? If government can suspend the laws, is confidence in the rule of law diminished? And I think the answer to that question, and I would very passionately argue an emphatic no. I would argue that the changes show that for government to work effectively, they have to work nimbly. We have to adapt quickly to the changing circumstances. We have to respond to risk. We have to respond to data. As Adam Gopnik asserted, with what I would describe as a great deal of sass, scientific medicine is not one more opinion on the spectrum of political grievance. The state obviously has to work within a legal structure that enables this, and our concept of legal norms needs to accommodate these things. What we can't afford to do is to simply return to our standard way of thinking about those legal norms when it comes to the debates about rights and freedoms. We have to think about the very, very stark fault lines that this pandemic has demonstrated. We knew that we had very deep issues around rising rates of inequality, that when it came to health, your postcode determined what your health outcomes were. A pandemic has put those things into a very stark frame of us having to understand that these are matters in which we all have a stake, that they're not simply matters that are just debates about rights of freedom versus the right to life and the right to health. It is very much about focusing on inequality that exists, and reducing that inequality has now starkly become a matter of life and death. It means that we've got to make sure that we see the state and individuals as part of a bigger relationship, one that includes our health experts or whatever experts we need to call upon for the different crises or challenges. It means we've got to rely on research institutions and most of all our people. When we understand that this is not a task of individualism but a task of collectivism, we begin to see that the individual freedom, social responsibility binary falls away, and it needs to be replaced with a very stark new understanding where they each reinforce each other. Individuals stop being discrete entities which are alienated from the whole, and the whole stops being something that's amorphous without individuals thriving within it. These are indeed challenging times. We are all deeply invested in trying to ensure that we are able to reduce the harm that COVID-19 is imposing in our own state and country. But it is also very much, I think, a time for global reflection. And before the advent and before the prevalence of COVID-19 across the globe, we were imposed and engaged in a different political and economic and legal debate and conversation. It is one that has arrested and I think changed the nature and the tenor of the way in which we need to think about the law and rights. My argument is essentially that inequality is something that fundamentally jeopardises our ability to rise to global challenge. Corona is one but example, but one that is reinforcing itself to us in very, very stark terms. No one can predict where this is going, and I want to thank you all for engaging and listening to my ponderings on these big issues tonight. It is a very consequential period, and it feels like everything we do at this moment matters, and it matters a great deal. And I want to really share with you that I believe, as immensely challenging as this time is, it is a very, very important opportunity for us to ask who has been hit hardest by this and why? What isn't working within our legal structures and what can we change for the better? How can we ensure that we create fairer conditions following this crisis so that human rights can be better realised? So it is not just people in precarious employment, so that we don't have an aged care system that essentially has consigned our older members of our community to an unbearable and unthinkable level of risk. That it is not a matter whereby your postcode necessarily defines not just the likelihood of you being caught up in a criminal justice system, but you being caught up in a global health crisis that determines whether or not you might live or die. These are very, very stark questions that we need to keep very, very focused on. I'm very delighted that RMIT invited me to this event tonight, and I want to thank RMIT. RMIT is obviously responsible for just such a large part of our city's vibrancy. Its story is one that is progressive and egalitarian, and it embodies its own motto, a skilled hand and a cultivated mind. Well, we need skilled hands and cultivated minds more than ever. So thank you, RMIT. Thank you to all of those that have taken time to join with us tonight. I'm very grateful to have addressed you and to perhaps have prompted some different thinking about some of the issues that those of us in the legal profession reflect upon. To those that are missing people that they love, that are climbing the walls, teaching children at home, that are very worried about people that they love, I want to encourage you to try and find a spirit of optimism and connection. I hope that the phrase "we are all in this together" is something that is capable of reaching beyond a dinky government tune or a Ben Lee song that some are familiar with. But it is something that we use to genuinely say that from an economic and social and legal perspective, if we do not reduce inequality, if we do not use the opportunities that this will present to reframe the role of the state, to reframe the role that the law has in reducing inequality, then it will be a very, very lost opportunity. I hope that you have a very inspiring and controversial and provocative discussion tonight. Keep well, hang in there, and please know that there's lots of help available to anyone that is struggling. Thank you very much.
Well, on behalf of RMIT University Law School, I really want to thank you, Attorney General, for taking the time from the incredible demands on your government right now that we know you're under, and really to deliver such an engaging and thoughtful lecture for us tonight. Also very inspiring in terms of keeping on through this difficult period that everybody's facing, and touching on the really important legal issues that you're having to deal with in your role, and the broader societal and health impacts of the crisis we're currently facing. I also want to thank Mike Williams and Tracy Lanza from your team for their help in making the event happen. And I know you have other commitments, so we'll let you attend to those now, and we'll continue on with our panel discussion.
Thank you very much. Thank you. Take care.
Thanks, Attorney. Should also thank the Attorney for her very kind words about RMIT and our law programs, which we're very proud of. So we're going to move into the panel discussion with my two colleagues from the law school now. Professor Bronwyn Naylor, who's an expert in criminal law, among other matters, among a number of other areas of law, and also Mr. Stan Winford, who's the Associate Director of the Centre for Innovative Justice, and has also done a lot of work in the areas of human rights and some of the human rights implications indeed of the current situation and the issues facing the Victorian legal system. Stan recently wrote a really interesting article about the impact on human rights of the lockdowns that we've been experiencing for some months now in the conversation. So thank you very much, Stan and Bronwyn, for joining us. I might invite each of you to just give a brief response to the Attorney General's lecture, starting with you, Stan.
You just unmute, Stan, sorry. If you just unmute yourself one moment.
I'm so sorry, everyone. I haven't done that all day today in many meetings, but there you go. It's always a good time. I'd just like to acknowledge the traditional owners of the land I'm respectfully living and working on, the Wurundjeri people of the Kulin Nation, and pay my respects to elders past, present and emerging, and to acknowledge distinguished guests, the Chief Magistrate and the President of the Children's Court among them. I'd want to thank the Attorney for her speech and acknowledge her many achievements and some of the commitments she's made. Her record shows that she's able to get very challenging and contentious legal and social policy reform done. Recent examples include the voluntary assisted dying legislation, laws in relation to wage theft, industrial manslaughter, and I'm confident, given her record and the work that we've done with Aboriginal organisations and individuals to advocate for a few key reforms, we're very pleased that she's made a commitment to decriminalising public drunkenness and establishing a Victorian spent conviction scheme. Both of these reforms are very critical on many levels for reducing the extraordinary levels of overrepresentation of Aboriginal people in our justice system and in our prisons. And both of these reforms have the capacity to better realise human rights and create fairer conditions following the crisis, for self-determination, for reducing barriers to participation in employment in what will be a very challenging labour market. So the 2 points that I want to touch on from the Attorney's speech very briefly are human rights and COVID, as Anthony's indicated, and also the idea of matters being on hold and ingenuity. First, in relation to human rights, clearly, as the Attorney's highlighted, they are more relevant than ever, and certainly they're under the spotlight. It's never been more obvious to people that human rights are what we're talking about at the moment, and the human rights we're talking about are your rights and my rights, and everyone's rights are at stake when restrictions are placed on freedom of movement or association. No longer are human rights the instruments in the abstract domain of lawyers. They're not a rogue's charter, as some have seen in the past, or loopholes mostly used by despised criminal elements to escape just punishment. What's been less obvious to some in some of the debates we've seen is that rights are not absolute. There's always a balance to be struck. And in fact, that's always been a key purpose of the Victorian Charter, not to inhibit or prevent government from doing what's necessary, but to make it clear that incursions on our rights and freedoms must be for a purpose, and that they're proportionate to that purpose, and that they're time limited, that they're no more restrictive than necessary. And it's also been a key purpose of our rights charters to ensure that people understand rights and that people respect rights, and it's been necessary to have a charter to embed a rights respecting culture in our community. And as the attorneys pointed out, this is actually a very valuable discussion to be having now. Too often public discussions about human rights can end up in a dead end, in absolutism, and those sorts of discussions don't really get us anywhere at all. But while some have been talking about rights in absolute terms, the conversations that have been happening show that we're in the midst of actually a very large community awareness campaign. Everyone's listening very closely to what is being said, and they're contributing to the conversation about rights. And I think it's great that the choices that are being made are much clearer than they would have been without having this framework for the discussion. We can see now why rights are being limited, how the exercise of power is affecting vulnerable people in certain circumstances, and we can learn from it. We've also learned that communicating decisions clearly in language that's understood and explaining the choices that have been made, involving people in the decisions that affect them and supporting them to comply, ensures that people perceive what's happening as legitimate, not so much because they fear punishment. About whether they'll be apprehended is often an important consideration, but it's building legitimacy because people are seeing how these decisions are being made, and that legitimacy comes from the fairness with which those decisions are being made, because people understand that they're made for a reason and that some of the choices that have been made are clearer. So clearly the kinds of discussions we're having now about rights can only increase the sense of legitimacy of the rules that our community must now follow. And of course, it's building respect for people and our institutions. Very briefly, the second point that I wanted to touch on was where the attorney highlighted that we need to find ways over the coming year to think about how we organise our legal system so that matters can be heard as quickly and as fairly as possible. And I think these are absolutely critical questions for our justice system. We've seen enormous change over a very short period of time. We've seen changes in the number of people being refused bail and a levelling off of the remand numbers, which have been growing. It shows that it may be possible to slow down what had seemed to be an inexorable growth in our prison populations. So the question for us is, how can we ensure that this continues? How can we use the opportunities that this crisis has presented to sustain some of the positive changes? The other thing that we've seen is that our legal system and our courts in particular can adapt. It shows us that change doesn't need to be as glacial as we might have thought, that there's great capacity for innovation in our system. And we also know that at some point in the future, we're going to have to deal with some big challenges. Backlog of cases is an obvious one, and that's been raised, and that might offer opportunities as well. So a very important piece of work over the coming months and into the future will be to identify and articulate some of the positive impacts that we've seen through the change that's been forced upon us, and what we can retain and what we can build on. What do we keep? What do we let go? But as the attorney said, as well as being fair, we may need to be quick. So in the rush to clear the backlog, how do we ensure that justice rather than just administrative efficiency is done? And one area where this challenge may arise, and that's something I'll very briefly touch on, is in relation to our specialist courts. So courts like the Assessment and Referral Court list that deal with people who have experienced mental health issues and come into contact with the justice system, our Koori courts, the drug court, those have all been affected, like everything else, by the COVID crisis. And some of these practices have actually been beneficial. They've removed some of the anti-therapeutic effects that people experience going to court normally through security. For lawyers, they've had to be less involved in crowd management, and they've had more time in many cases to talk to their clients about the issues that they face. And as the attorney pointed out, remote hearings can be a great leveller, and remote and a level playing field, or magistrates sitting around the table with the people that they're judging, is a critical feature of some of these courts. So in many ways, they've enhanced aspects of what we think work well in a therapeutic sense. Judicial monitoring, many people I've spoken to have reported that that's been better for them over the phone than going to court. And accessibility, justice has been brought to people rather than having forced them to visit courtrooms that aren't working so well. But there are also challenges, and this is what we also need to be aware of. Face-to-face contact is important. There's a loss of a sense of engagement and warmth that comes from that. In some cases, fewer people are being identified and referred into these courts because there's not that contact. There's a loss of capacity to identify people for whom these kinds of courts might prove useful. Some of the lawyers are reporting that it's harder to negotiate outcomes with police because everything has to be formalised, has to be through a video link or in writing. So there are a lot of issues that we face. The question is, how can we ensure that our courts, despite COVID and despite the challenges that we face in dealing with backlogs, can remain positive intervention in people's lives, that people remain at the centre, that they can meaningfully participate in the justice process, and that our future responses ensure that we retain what's essential to ensure that justice is done. So the opportunity is there. Clearly the government will be receptive to the need to address these challenges, and the legal system and our courts have shown that they're able to adapt and work together collaboratively to address these challenges. So exciting times ahead. Thanks, Anthony.
Thanks very much, Stan, and I'll throw to you now, Bronwyn, to give your views on the attorney's lecture.
Great, thanks, Anthony. Thanks, Stan. I really enjoyed listening to the attorney's presentation, and I just wanted to make a few comments, I guess, that sort of flow from both Stan's comments and those of the attorney about this issue of balancing different types of rights whilst working out how we can best manage a legal system that's going to operate well and efficiently whilst protecting the rights of people who are most vulnerable, I guess. So what I want to talk about here then is how the pandemic is affecting prisons specifically. And after I've made a few comments, we'll go back to Anthony to the Q&A, because I know there's quite a lot of questions coming up. So first of all, in relation to prisons, you will have seen lots of reports in prisons around the world, and it's obviously a risk in closed communities. You have real problems with space, with social distancing, with hygiene, and it's been great to see how Corrections Victoria's been managing COVID infections in prisons and youth detention facilities. We haven't seen a sort of a huge outbreak as we've seen in some other countries. We do need to think very carefully about how that's being managed and whether people are effectively in solitary confinement for extended periods to prevent the spread of the virus. So, and really I'm just raising these points for us to be thinking about as we exercise this balancing process and think about how we're going to manage this. So when people come into prison, they then go into 14 days in quarantine. Is that amounting to solitary confinement. Similarly, people in prisons, if they become unwell and have to be isolated. So we need to be making sure that isolation for prisoners, as well as indeed for us and the general community, doesn't go any longer than needed. So going forward, I guess a factor that might be something that should be thought about will be the importance of having prisons that are not used at full capacity, to make sure that prisons have the scope for safely isolating people in the future, just as we're requiring people to find extra space actually to self-isolate in the community. We also need to think about how closing prisons to outsiders affects family contact. So Corrections Victoria has been innovative in introducing remote Zoom, Skype contacts between people in prison and their families to address the fact that families and friends haven't been able to visit prisons since, as I recall, early March this year. And you might not know that internet is not generally available in Victorian prisons, and this type of video visiting hasn't been widely adopted in Victoria before, other than in a couple of prisons. So it's really great to see this rapid evolution of innovation in this area. Both the attorney and Stan have mentioned this issue about what sort of learnings are we going to have from the pandemic, and it's going to be important to see what we've learned from this. So I think it's going to be important to keep the online access that's being provided in prisons, does seem to be working well, and for family and friends living a distance from prisons, it could also become a way of accessing education more conveniently for people in prison. But we need to remember, as others have said, that's not a substitute for the personal, for human contact when that's possible. We're all recognising the limits of living online, and we're all, I think, valuing more and more the importance of face-to-face relations. So we don't want to see digital developments and innovations becoming the basis for putting aside interpersonal connections. One other point I just wanted to make here was that in terms of learnings, we've been seeing how vulnerable people can be when they're in closed institutions. So we're still discovering the problems that have been occurring in aged care facilities and in some residential disability homes, for instance. We've seen how conditions can deteriorate, and we've seen how abuses can occur when there's no community access. And this really highlights the importance of having rigorous independent inspections of all places where people are locked up, where they can't leave, where they might not have people coming in from outside. This includes aged care and disability care, which has been high on the agenda obviously very recently, also prisons, and at the federal level immigration detention. There are quite a few inspecting bodies in Victoria, but it's been difficult for inspectors to keep up with physical inspections of places where people are detained, both in Australia and of course all around the world. So Australia has actually taken important steps to improve this monitoring. The federal government ratified this important UN treaty, OPCAT, a couple of years back, and that means that Australia has promised to have comprehensive external monitoring set up for all places of detention in Australia. This also requires work by states and territories, and it's going to be really important to see what Australia plans to set up, which hopefully we'll be hearing about from the government soon. But I know we have lots of questions coming up, so I'm going to hand over to Anthony for the questions. Thank you.
Thank you very much, Bronwyn. And yes, we do have quite a lot of questions and not that much time left, so I'm going to have to be a bit selective about these and pick out a few that I know our panel are well positioned to answer. And there was a question about remand from Donna Evans. The backlog of remand cases. Is there a plan to address the court hearing delays, such as special court fixtures, bringing back retired magistrates, weekend court listings and so on, to clear up the backlog? There seems to be a very high risk that people will remain in custody for extended periods while they await delayed hearing dates. And I know you can't answer for the government, Bronwyn and Stan, but perhaps you could address some of the issues that question raises. Either one of you.
Stan, you might want to start with that one.
Sure. Well, absolutely. People who have been remanded in custody are innocent until proven guilty, and in recent times there's been a very significant growth in the number of people who've been remanded, largely because our system is struggling to get through the matters that it has before it, but also because of changes to bail laws and other legislative changes that are in effect bringing more people into the system. Housing and access to homes is also a big factor in whether or not people are granted bail. So I think I agree with the question, which is that in effect there needs to be a plan to address the remand backlog, because it's not great for people to be in custody for extended periods of time, and certainly there have been a number of bail applications where the point about the conditions within which people are experiencing custody at the moment, including the risk of infection and the very stringent measures that are being taken to isolate people and prisoners when they come in to courts, are making time spent in custody even more arduous than it ordinarily would have been. So I think any measures that can be introduced to address the backlog are really quite critical at the moment.
Did you want to add anything, Bronwyn?
No, I think that's covered it.
Okay, great. There's then a question about the protests that we've been witnessing. Let's just locate the question. Do you think it is reasonable, this is from Stephen, is it reasonable for people to try to organise socially distanced public non-violent demonstrations in times of lockdown? I might ask you that one, Bronwyn.
Okay, thank you. Well, that's quite a challenging question, isn't it? It's obviously really important that the community has the scope for being able to protest safely within the rules and so on in this area, and we saw early protests that took place earlier on in the period of lockdown. At the same time, protests need to be addressing issues which are not going to, I guess, challenge and undermine current rulings in relation to, for example, the safety and security of people, or setting up information that's not well-based, not evidence-based. So that, I guess, that becomes harmful to the community. Again, it's an area where you've got to find the balance in terms of the various rights that we're talking about. So I think that that's going to be very much a question of that sort of balance, achieving that sort of balance to make sure that any sort of protests are not going to undermine public understanding or safety.
Thank you. We might have to wind up with this one, and I'll throw it to both of you because we are running to the end of our time, but it sort of looks a bit forward, and it's a question from an anonymous person. Looking to the future and the possibility of a different or another pandemic, hopefully many years down the track, how could the legal system be better prepared to tackle issues of this magnitude? Could I go to you first on that one, Stan?
Yeah, well, I think the key is learning from what's happened, and as I was saying, and as the attorney was saying, thinking about what it is that's been valuable in our responses and what it is that we can retain and perhaps enhance in the future. I think it's clearly not chipped away at some assumptions that people have always had about courts, and I think legal futurists like Richard Susskind have asked the question provocatively, you know, is a court a place or is it a service? So those sorts of issues and those questions, I guess, are going to help us think more about what courts of the future might look like. But I think the other thing is that clearly technology has a role to play, and I know that the Magistrates Court in particular has been very rapidly working to address that side of things, and that's always going to play a key part as well.
Thanks. And to you, Bronwyn?
Yes, well, Thank you. Well, I think just perhaps harking back to the comments I made previously about prisons and places of detention in a different, like taking a different perspective on this, I think that the fact that, for example, our prison numbers have fallen, the fact that more people are getting bail and what appears to be quite successfully, and the fact that in many other jurisdictions prison numbers have decreased as people have been released, means that we need to be only using imprisonment where it's absolutely necessary. So I think it would be a really good outcome, learning from this pandemic as to why are we using detention and how are we using it most efficiently, and are we detaining the right people, or are we in fact detaining some of the wrong people? I think more generally as well in relation to aged care, disability facilities and so on, again it's highlighted the importance of proper regulation. Obviously we can't go into the detail of that here, and as I've mentioned, really thorough regulation and oversight from an early point, because we just can't afford to have these sorts of problems arising another time.
Thanks very much, Bronwyn, and thanks both to you and Stan for your very insightful responses to the Attorney General's lecture, and also the additional difficulty factor in doing so without having had a great opportunity to see her speech, but then also in your very interesting responses to the questions. I'm sorry to the audience that we couldn't get through more of the questions, but we are running already a little over time. I do thank the audience very much for your engagement with the lecture this evening, and the many questions that came through demonstrated that. In closing, I just need to thank a few people who helped make tonight quite a success. Thanks to Professor Julie Cogan for her introduction, and Professor Kathy Douglas for providing the Graduate School of Business and Law's support for this event, which happens every year. Again, thanks to Bronwyn and Stan for your contributions. Thank you to the College of Business and Law events and marketing teams, in particular Lauren Gotals, Reka Ryan, Simone Goodwin, Alicia Olive, and especially to Alyssa Pullar, who worked tirelessly on the event, pulling it all together behind the scenes for months now. Thank you very much, Alyssa. You know I really appreciate it. And again, thank you all for attending in quite large numbers. We're very pleased to have been able to continue delivering the annual Higinbotham Lecture in a different format this year. We will follow up to all who registered in the next week or so to inform you about opportunities to continue to engage with RMIT Law, whether that be through connections for our students, in internships and placements, research opportunities with our Centres for Innovative Justice and Business and Human Rights. And also, I know that there are some people listening and viewing the lecture who are interested in our Juris Doctor degree, but more significantly, our new Bachelor of Law degrees that start next year. We hope that any Year 12 students watching and your families have found this engaging, and that we can get you interested in enrolling with us next year. To find out more about that, please use the link on the screen. Thank you everyone for attending, and good night.